But my name is Jonathan Adler. I'm a professor here at Case Western Reserve University School of Law. I'm also director of the Center for Business Law and Regulation. And let me welcome you to what I think is really an exciting event. We're here to talk about a new book that Thomas McGarity and my colleague Wendy Wagner have recently published with Harvard University Press, Bending Science: How Special Interests Corrupt Public Health Research. An important book that analyzes what happens to science when it gets put into or relied upon or used for the policy-making process, the tort process, and the like. And I think it's fair to say, and I don't want to give away any of what you will hear from Wendy and Tom, but the picture they paint is certainly one that's not pretty and one that should concern us. I'm going to very briefly introduce our speakers because they have a lot of interesting and substantive things to say, and you're here to hear them, not to hear me. First up is going to be Wendy Wagner, who's one of my colleagues here on the faculty at Case Western Reserve University School of Law. She is also the Joe A. Worsham Centennial Professor at the University of Texas School of Law, and we are very fortunate that through a series of events she has been able to rejoin us here at Case for at least half of her time. Previously, she's been a visiting professor at Columbia and Vanderbilt. She has a master's in environmental studies from the Yale School of Forestry and Environmental Studies, worked on the Sixth Circuit, has written a wide range of articles that are too numerous to mention, one of which, if I remember the title correctly, the Science, Trade, and Toxic Risk Regulation is certainly one of the most important articles written on that subject. Her co-author, Thomas McGarity, who will be here, we hope very, very shortly, is the R. and Teresa Lanzano Long Endowed Chair in Administrative Law at the University of Texas School of Law. Also a very prolific writer. Also has another book about to come out from Yale University Press, The Preemption War, When Federal Bureaucracies Trump Local Juries, and among many other things, was an attorney advisor at the Office of General Counsel at the US EPA. Commenting on Tom and Wendy's book, we have two very distinguished and very knowledgeable commentators that I think we're very lucky to have with us today. Commenting first is going to be Christopher Schroeder, who is who is Charles S. Murphy Professor of Law and Public Policy Studies at Duke University School of Law, as well as the director of the program in public law at Duke, among many other things. He was acting assistant attorney general in the Office of Legal Counsel in the Justice Department during the Clinton administration, and is also co-author of what I believe is still the best-selling environmental law casebook, Environmental Regulation, Law, Science, and Policy. Also commenting will be E. Donald Elliott, who is chair of the Worldwide Environmental Health and Safety Department at the law firm of Willkie, Farr, and Gallagher in their Washington, D.C. office, but was also previously a member of the Yale Law faculty, a tenured professor there for 12 years, in addition to having been general counsel of the U.S. Environmental Protection Agency in the first Bush administration. So I think we have a fabulous program for you. Wendy is going to begin giving you a brief overview of the book. We will then get commentary from Chris and Don, and then open it up to questions. And after the event, we will have a brief reception in the lower rotunda on the other side of this wall. So without any further ado, I'll turn it over to Wendy.
Great, thanks. I'm pitching for my co-author, Tom. He was supposed to present, so instead you got me. I apologize for that, but I'll do my best. I first want to give some thanks to Jonathan for putting this together. It was extremely nice to have an event like this, and also terrific thanks to the two commenters. Not only did they read the book, which I have to say is no small feat, but they also actually got on a plane and flew out here and left much warmer climates to come to cold Cleveland and offer comments, and as I understand it, actually are writing something up. So that's true collegial love that they're showing for us, and we really appreciate it, no matter what you have to say about what we have to say. So as Jonathan indicated, my job is to very briefly set up the book, and that's what we'll be sort of critiquing and hashing out through the rest of the time. So hopefully I'll give you the bare bones, enough to know what we're talking about. And before I get into the book itself and its argument, just to put a little history behind the issue. Probably starting in the 1990s, there was increasing concern about the quality of the science that was being used for public policy. And maybe the one sort of event that kicked it off was Peter Huber's Galileo's Revenge. It's a book published about how the courts were using junk science. And a lot of jury verdicts actually were probably unreliable because the courts were being so generous with admitting a lot of this bad stuff in. And basically the same allegations started carrying over to the agencies. That the agencies, particularly the public health and regulatory agencies, also were using junk science or science that wasn't sound, and a lot of the resulting regulations that they were promulgating, therefore, were pretty much unreliable. So this is basically the debate we're jumping into, and we're saying, you know, that kind of focus actually misses a larger problem that's beneath it. The problem isn't so much how the agencies or even the courts are producing or using information. The problem is the special interests that are involved in extensive manipulation and corruption of a lot of the information that forms a basis for this decision. Now, that's not to say these other concerns are misplaced or there's not other issues going on, but the more we look at the issues going on with the quality of science used for public policy, the more we see a significant share of the blame lies at the feet of all the special interest manipulation that goes on with the quality and even in the existence of this science and making sure we have the best available science. So the book focuses on this general argument. I'm going to go through three basic components of our argument. First, you know, what is it about this particular area that leads to this kind of special interest engagement in science that works not only to the legal institutions' detriment, but also to the scientists themselves. Take you through a couple examples of exactly what I'm talking about, what's actually going on, and then close with some proposals for reform, at least sort of first-level proposals, not at all suggesting that that's going to solve everything. So, you know, what is it about this particular area that creates a lot of problems? First, to back up, our book is only about public health and environmental research. We talk about special interest manipulation of that body of research. Now, our arguments may apply equally well to other places, to economics, to other areas of social science, to other areas of natural science, even to criminal forensic evidence. This is our area of expertise, public health and environment. That's where we focus. So we focus on that particular area of research, and actually that type of research, most of the research used for public policy, and here I'm talking about agencies' rulemakings and also courts, is very applied. Most of it is applied at a very weak and scientifically vulnerable level. What I mean by this is we actually don't have a lot of scientific theories that explain how pesticides affect animals in the field or how they affect ecosystem function. A lot of times we don't even have scientific mechanistic theories for how cancer develops, or not robust theories. As a result of a lot of this, applied research is really trial and error. You know, it's shooting a mouse with some stuff and seeing what happens to the mouse. So it's weak science. It's very vulnerable, in other words, to differences on how you do the methods, what the results actually are. At the same time, a lot of this research actually isn't interesting so much to mainstream scientists. The ones in academic institutions trying to get tenure really aren't terribly fascinated by a publication on how a particular type of pesticide affected a specific type of animal in the field. These are very narrow studies, and again, because of the trial and error nature, they just don't get a lot of scientific oversight. So this stuff is weak methodologically, weak theoretically, and also the scientists aren't terribly engaged in overseeing the quality of this stuff. At the same time, this same applied research in public health and environment is extremely important to some interests. A lot rides on the findings of this research. A lot of dollars can be pinned to the research of a single study, for example, linking a toxicant to particular adverse effects. So there's a horrible cost associated with research that all of a sudden discovers that asbestos is leading to lung cancer, or that secondhand smoke is leading to lung cancer in people that are exposed. A lot of money rides on those kinds of findings, and as a result, special interests have a very strong interest in what the results are. They want to make sure that the research that is being done correctly, particularly when it comes out adversely, and they think they're going to be paying big liability judgments or seeing a lot of expensive regulation. But sometimes they go beyond that. Not only do they want the research to be of the highest quality, but they may actually want to manipulate it a little bit. They may want to produce research that suits their ends, or attack research that's actually pretty legitimate that cuts against them. So there's a lot associated with this research. You put these two things combined, very weak, sort of vulnerable applied research in an institutional pressure cooker where so much rides on it, and you really have a recipe for some significant problems and specific types of manipulation. So in the book, we talk about this specific type of problem and then the types of things that happen to it. So we actually commissioned a cartoon. The book has 200 very dense pages on all the different ways that this kind of applied science has been manipulated by special interests. Now, when we're looking at the manipulation, we're not just talking about funding studies and then backing off. We're talking specifically about sponsors that decide what kind of results they need or how they want those scientific findings to appear, and then work backwards to make sure they get that kind of a result in the scientific literature somehow. So it's a very sort of narrow, easy identifiable problem in science. We find out, oh, these aren't very focused. Is that my problem? Well, that's okay. You can't read them anyway. Even if they were focused, I promise you couldn't read it. But basically, each chapter looks at different tools, different ways that science can be manipulated and distorted, and looks at different subtools within these techniques for how it's distorted. And in about 90% of the cases, you can't read it, but in 90% of those cases, it's basically being manipulated or corrupted using legal tools that are available. So it's being done not in spite of the legal system so much, but because of it. The legal system is providing the tools that sort of enable this kind of manipulation. It's enabling it through permissive subpoena powers, through permissive scientific misconduct proceedings, through a variety of techniques I'll show you. So a lot of our aim is actually taking at the legal system and how it permits a lot of this stuff to go on. So to give you a few examples of the evidence, and these are very few. One technique to manipulate science is pretty straightforward, is to commission science, decide what you want that particular research to say about your pharmaceutical drug or about your particular pesticide or whatever the case may be. And you find scientists using contracts, non-disclosure contracts, to make sure that they produce the result that gets your finding. And they, in turn, or with the help of the sponsor, can manipulate the design, data collection, all varieties of features of the scientific process to make sure that they kind of get the results that are close to what they need. Lots of examples of this. We have about 40 pages of examples. Just to give you one of my favorites, one of the more blatant ones, but it's cute. Ephedra, a weight loss pill. So in this case, they really wanted to show how effective ephedra was, the manufacturers of ephedra. And so they commissioned a study, a clinical trial with humans, to try out ephedra and see if they lost weight over a period of time. Well, when they enrolled the patients, they had a handful of obese patients or people admitted into the clinical trial that were trying ephedra, as well as a lot of other weight ranges. Through the course of the clinical trial, a number of the obese people actually dropped out, said, I don't want to do this anymore. But when they were actually calculating the weights to determine the effectiveness of ephedra, they took the intake weights, which included about 6 obese people, and then they calculated the outtake weights, which excluded the obese people because they were no longer in the trial. And ephedra looks so incredibly effective in terms of its weight loss, much more effective than it was. Now, that's a blatant example, although I think actually that study was published and it just wasn't caught in peer review. It was one of those sort of sinister, devious tricks. The peer reviews wouldn't even know to look for. Those kind of tricks, though, are easier to do than you might imagine. And the lower you go into the design of the study, the more you can manipulate things in pretty clever ways. Now, the funding effect is actually a statistical effort to find not only ends-oriented studies, but actually the effect of sponsor bias in general. The funding effect has been actually published in several journals or occurrences of the funding effect or findings of the funding effect. This is one particularly well-known one that was published in JAMA, the Journal of the American Medical Association, about 6 years ago. Basically, they did a meta-analysis on over 1,000 biomedical studies. And they found that when a sponsor sponsored the research, and we're not sure what the contractual relationships were, so it's probably different kinds of sponsorship control, but when a sponsor sponsored the research, there was a statistically significant, powerful correlation between the outcome of that study and sponsor control. When a sponsor controlled it, it was to the right of the line. The results were much more statistically likely to be in favor of the sponsor. When the sponsor didn't fund it, they were more in the middle on the line. So the funding effects also suggest that even just at the level of financing, there's powerful correlations. So another way to manipulate science, beyond actually commissioning the research to get what you want, is to suppress or hide the stuff that you do commission that you don't want after all. Using contract law and typical non-disclosure contracts usually can at least scare the scientists into not producing this. I have up on the board some of the poster children of suppression. Asbestos, all these incidences actually were exposed through tort litigation. pretty dedicated, determined plaintiff attorneys that were determined to find these smoking gun documents. And actually, most of the suppression we've learned about in public health and environmental law has come from tort law, not from agency regulators. And increasingly, there's a concern that even in tort law, some of this information may not be coming to the fore. Defendants can actually sometimes convince plaintiffs to accept a bonus payment if they seal the records and seal all the documents that were discovered during discovery, including these smoking gun suppression documents. So there's some evidence, in some cases at least, that some of this was actually uncovered by plaintiff attorneys maybe 5 or 6 years before, but it was sealed because the plaintiffs accepted a bonus payment. It's only that final plaintiff that won't accept the bonus payment where the information actually hits the light of day. Okay, in another attack. This one I love. I actually love the last two because they're so despicable and disgusting, and I'm really into that stuff, as my students know. This is a technique that's so clever that it's beautiful. This was actually, I would say we should give intellectual property rights to the tobacco industry for coming up with this. And this is the idea that when you have credible research out there, and you don't want it, and you know it's really adverse to your economic interests, it's really ugly for your future, you throw sand in it, as much sand as you possibly can. You critique the hell out of it, is exactly what you do. And so for the tobacco industry, the research showing that tobacco caused cancer led to commissioned critiques that were determined, that were specifically, had the purpose specifically of trying to show that those studies had numerous flaws and shouldn't be trusted. When research came out with secondhand smoke, the same kind of barrage of criticism went out and actually hit the media as legitimate problems with this research on secondhand smoke causing cancer. So it's a very clever technique, and why it's so clever is because vigorous skepticism, actually heavily vetting science, is a principle of science. In fact, that's a scientific norm. Scientists cherish the ability to vigorously debate and engage in skepticism. And so camouflaging these critiques and attacks as legitimate efforts to be skeptical really makes them look good. But they're different. They're different because in this case we have a sponsor who hires people to do nothing but poke holes in studies. It's not an academic researcher saying, this study's really bad, I need to write a letter to the editor. This is not the kind of thing that should be called science. These instead are paid for critiques, where they're poking at every single feature of the study, including many features that scientists themselves might find perfectly acceptable or methodologically within range. But the effect is for public policymakers to see these studies where there's 20, 30 problems with them, even though scientists would find most of those problems to be trivial and even contestable, and it basically disparages the study. Another technique that kind of goes along hand in hand with attacking the science is going after the researchers themselves. Now, this is used rarely, but when it is used, it is truly despicable. So in this case, what you do is you take a researcher who's coming out with very important discoveries that are adverse to your interest, and you go after them. You go after them with legal tools. And you do this not only to harass and intimidate them, but to disparage the reputation, so people don't view them as good scientists. We have about 35 pages on the techniques of this. Just to point one out, Paul Fisher, the second guy, his research looked at Joe Camel. Do any of you remember Joe Camel? Just adorable little camel. And he actually looked at how children reacted to Joe Camel. And he found that kids liked Joe Camel better than any other childhood icon. They liked him better than Ronald McDonald, Bozo the Clown, even my favorite Mary Poppins. You know, Joe Camel was at the top of the list. He published this in JAMA, a very reputable empirical study. But this was not something R.J.R. Reynolds was happy with. It suggested that they were actually trying to engage children in liking cigarettes. So what did they do? In unrelated litigation, they filed a third-party subpoena against all the records in his lab, including the confidential records of the children's addresses, names, phone numbers, the whole ball of wax. Now, this is a subpoena power that is provided by federal law, giving a third-party subpoena to researchers whose research has some relevance to the litigation. But the federal court caught on real quickly. They quashed the subpoena, said, you've got to be kidding, you can't do this. And so then R.J. Reynolds went to state court, and they actually convinced a state court to require him to release all these records, including the confidential records, under the State Freedom of Information Act, because he was at a public medical college. After this experience, he also had scientific misconduct allegations filed against him by people that were paid for by the tobacco industry. After this, he left his tenured post. He had tenure and now practices internal medicine in rural Georgia. So at least they didn't succeed in killing his research, but they did succeed in killing his research career. So you can use these tools quite powerfully. And again, these are tools that are coming from the legal system. And in fact, our criticism really is leveled against this very permissive legal system. In most of these cases, the legal system is doing surprisingly little to anticipate or to counteract these effects. So, for example, agencies don't require, when they get the research in to help them understand the safety of a pesticide or a chemical, they don't even require disclosures of what role the sponsor played in that particular research. They don't require simple things that biomedical journals all require, just as a condition to understand the research used for regulation. We do federally have a law that requires data sharing, that when you produce a piece of research that informs regulatory decision making, that you have to make that data available. But that requirement only applies to federal research. It doesn't apply to private research, even when that private research informs regulatory decisions. We have very poor requirements on requiring companies to report adverse effects that they discover in their products over time. Most of these requirements are essentially unenforceable. And a lot of the legal tools I've talked about, sometimes you can't use them in the end, but there's very few sanctions for abusing it. There's very few sanctions for kind of pushing the envelope and trying. So surprisingly passive legal system that lets all of this stuff go on. So what do? Well, we have 3 sets of reforms, and actually because it's such a depressing, seemingly pervasive problem, we understand that these reforms are just the tip of the iceberg and what we call the low-hanging fruit. But they're an effort to kind of start to engage in the problem and get the legal system engaged. So the first set of reforms actually suggests that the scientific community and actually scientific journals have a lot of requirements in place that could be codified into regulatory law. Biomedical journals require you to tell how much the sponsor controlled your research or whether your research was ghostwritten. Biomedical journals also expect you to share your data that underlies your published studies. So just codify these. These are mandatory regulatory requirements, or they should be, we argue. Also, much stronger adverse reporting requirements. So maybe even plaintiff attorneys who are involved in lawsuits where they're sealing suppressed evidence may have a reporting obligation that can actually be civilly fined, so to broaden and expand requirements for reporting for adverse effects. A second set of reforms actually looks at the abuse of legal process and says we need to create some sort of sanctions for this. You know, if you're abusing subpoena power or filing scientific misconduct charges without a lot of basis for it, there need to be some consequences to that besides simply losing that charge because you've tainted a reputation. So we call for more sanctions for abusive process and maybe also more mechanisms for other parties beyond the government to start to police the quality of this regulatory science. We have pretty specific, somewhat tedious suggestions for broadening the number of tort claims that are available, including providing scientists who have been harassed themselves potentially some sort of tort remedy for that kind of harassment. Those are difficult reforms, though. They walk a bit of a tightrope because we don't want to all of a sudden create too many remedies for harassment because those could be used by scientists that actually have done terrible things, and then they can file that claim against people who make disparaging comments about their research that are in fact justified, and then they can say they're harassed. So it's a very difficult thing to solve, but we try to come up with some suggestions. The third set of reforms, which sounds like throwing it in the towel, but I don't think it is throwing in the towel, is to suggest that, you know, we need to rethink our use of science when we develop public policy. I think a lawyer's automatic response is science will solve this, let's reach for science, let's base everything on science. And if the applied science is going to go through this kind of hell, then perhaps we need to try to use it only when we absolutely have to. If we can't make public policy on a particular issue without using the science, then we have to go through this process of figuring out how to discipline it so we get credible science appearing. But if there's another way to engage in public health protection that doesn't involve so much intensive science, then perhaps we should do that. I have on the board here a couple pictures of pollution outfalls. And in fact, almost all of our environmental statutes actually require industry simply to implement the best available pollution control technologies, which essentially doesn't require all the scientific knowledge about the environment. It kind of circumvents a lot of these problems because it's an engineering issue. So we ask for people to be a little bit more guarded about their sort of automatic reliance on science. So with that, I'll open it up to our distinguished commenters. And I don't know, do we have an order?
Yes, Chris.
Okay. And should I just try to make this disappear? Yeah, if you can figure out so that we don't have to have, although we could, yeah.
Nope, one more. There we go.
Well, thank you very much. Thanks to Jonathan for inviting me and for Wendy and Tom for writing such a terrific book. It's a pleasure to be here to talk about it this afternoon. My first inclination after reading it a couple of times was just to get up for 15 minutes and gush about it, about how much I like it. But
That's okay.
But within the cultural norms of this strange academic tribe, that's inappropriate behavior at one of these sessions. So instead, I will try to shed, I'm not going to be terribly critical of anything about it because, as I say, there's much to commend and very little even to question. I thought I had a list of objections the first time through, and then I went back and read it again and I said, nope, they've answered that. They figured out how to qualify it there. So I do want to make some remarks that frame the problem in a perspective that may shed a little additional light on the problem that they've identified in a terrifically researched and splendidly written contribution that I think people are going to be referring to for a long time when being concerned about bent science. So let's start just by reiterating that definition of what their target is. Bent science, they say on page 45, consists of ends-oriented research and critiques of research that work backward from a result, and for that reason, not true science. And then a little later on, they actually say it's the antithesis of science. Bent science is having a result in mind and working back to get that result out of something that superficially looks like science, but is making the mistake along the way of being driven by the result and not driven by anything having to do with scientific methodology and technique, which at some point, in order to be science, has to sort of be let loose to roam and come to an endpoint that's driven by the methodologies. Now, the methodologies may be disputable. There may be more than one. It may be contestable which is the superior one to use. And in lots of these areas of policy-relevant science, there is reason to dispute and question. But if it's going to be science, at some point, the method has to be able to roam free. And the idea behind bent science is that the undertaking is constantly being guided by the importance of ratifying a result that you've already reached. And so the book is filled with these alarming studies, some of which Wendy's has recited, and I can assure you the book is rewarding in the sense that there are many, many more case studies throughout the chapters that identify the problem of science being bent. And your first reaction, my first reaction, is these studies are utterly alarming. And then my second reaction is more or less the same as the chief inspector in Casablanca when Rick's casino is being closed down. Shocking that there's gambling going on in this place. Because from a larger perspective, it would perhaps be even more alarming if you didn't, on a hard look. Hello, Tom. Welcome.
We're just starting the critiques.
Oh, this is great.
Your presentation was great.
Appreciate that.
Yeah, no, it really wasn't great, but
Just to bring you up to speed, I've just spent the last couple of minutes blaming you for anything that's wrong about the book.
I can get all the blame.
If we did this at Texas, I'd have more problem, but this is Wendy's home
right.
turf. It would be alarming if you didn't find at least a certain number of instances of this behavior. And so one question that seems unanswerable to me is how far we've progressed above that level that you might expect to have occurred anyway. Just how deep and serious is this problem? And they candidly admit there's really very little way to tell. They've certainly well documented the cases they discuss. But is this the tip of the iceberg or is this the iceberg? Well, it's probably neither one. There's probably something under the water there. We just don't know what the size of the problem is. But I think there are four conditions that contribute to the Rick's Casino sort of reaction being the proper one to this problem. One, as Wendy says, one element of that environment is that increasingly public decisions and public decision makers are asking science to provide the factual predicate for public policy decisions that have significant economic consequences to well-organized groups, firms, organizations. The first regulatory agency for occupational and public safety was the Federal Steamboat Boiler Commission, which was established in order to create some common standards for the boilers that went on to steamships. And it was an easy problem to identify, and then it turned out to be relatively simple to write some regulations for standards. Utterly obvious when a boiler blows up. Doesn't take a lot of tricky risk assessment or regression analysis to tell you that that's the problem. But when you've moved into a world in which carcinogens have latency periods of 20 years, in which the demand of the public for new medicines is such that you could never run in advance of marketing sufficient safety studies in order to demonstrate what the magnitude of risk associated with a drug that you've concluded is effective is going to be, you're in the realm of risk management and risk analysis, and you're going to be looking to scientific techniques to give you some handle on the magnitude of those problems in an effort to help you make your judgments. So we're in an area in which public decisions increasingly rely upon the kind of information that is being bent in Wendy and Tom's book. The second ingredient that creates an environment for this kind of behavior is one of the seminal lessons of the school of thought called public choice theory, with which I have some significant problems in some of its aspects, but I think it's absolutely dead on in insisting that we recognize that at least a good percentage of the time, individuals tend to be goal-oriented. The goal tends to be self-interested, and people are capable of doing reverse engineering. They're capable of reasoning back from a result to figure out what move I need to make at step one so that things turn out okay at step three. Now, what public choice is relentless about is insisting that you ought to be alert for that behavior everywhere. Everywhere. Whether it's the decision to get married, or the decision about bending science, or the decision about whether to merge with another company in a rapidly developing market, you ought to be alert to the fact that one of the strong motivations is goal-oriented, self-interested behavior. Now, at one point in time, we liked to think that there were a set of jobs that were relatively immune from this kind of pressure. We called them professions to distinguish them from jobs. And anybody who's worked in the legal business, in the real legal business, the kind of legal business Don does, and the kind many people in this room I'm sure have had some experience with, you know how much the legal profession has become recognizably a big business today, and firms need to be run sharply with an eye to the bottom line. When I first went to a law firm in San Francisco in the early 70s, they liked to say we were one happy family, work hard for us and you can have a job forever, the kind of thing that General Motors used to say to its employees. Now, of course, the mantra around most firms is you eat what you kill. So things have changed. Science is often considered, or medicine, often considered immune from these kinds of pressures. But of course, those are ideal types, and there certainly are many scientists and many doctors who are relatively immune to the pressure. But there are many who succumb for one reason or another, particularly if the dollar sign becomes large enough. And as Wendy says, and Wendy and Tom say so well in the book, that what we're really talking about with respect to policy-relevant science is, from the point of view of a first-class, cutting-edge researcher, pretty pedestrian stuff. So you're going to get people involved or ready to be involved in the lucrative side of this sort of activity, producing policy-relevant science, who might, statistically speaking, have, on average, fewer scruples about this kind of behavior than the folks who are angling for a Nobel Prize, which is harder to achieve if you've had significant problems with your scientific research and the credibility of your research in the past. So I don't want to be a critic of self-interest. Self-interest is an extraordinary engine of entrepreneurship and growth and innovation and creativity, and the idea that you can marshal people's self-interest in order to develop better science or do better medicine or create small jobs in small businesses is a vital part of our socio-economic structure. The ideal is can you marshal that self-interest? Can you get people who are self-interested to play within the lines, to abide by the rules of the game? We like to think that we can, but it's a relentless struggle. And I think that what they have documented so well in the book is with respect to bent science, we haven't yet thought hard enough about how you get people to play within the lines. And I think there are two conditions here that make going outside the lines particularly tempting, beyond the ones I've mentioned already. The first additional condition is it's often hard to tell bent science from straight science. Because oftentimes you need to get inside the head of the researcher and figure out, is he or she engaged in reverse engineering, or does this eureka just happen to be a result that is very beneficial to Merck or to Dow Chemical? Now, they have done an excellent job mining the literature and doing their own original research to demonstrate quite convincingly that in a number of cases, ex post, you can peel back the story and become fairly reliably convinced that bent science is what you're confronting. But ex ante, this is a very hard problem to figure out how to police. And you've got a situation in which what the economists call asymmetric information. The scientist knows what his or her motivations are, but the person who's reviewing the science doesn't. And so it's going to be difficult to detect. And then the last condition that generates the environment for this sort of problem is that a number of problems with bent science, or what the book identifies with bent science, it's not exactly clear where the line is, and whether somebody's playing inside of it or outside of it. So for those who haven't read the book, I'd make a recommendation that as you go through it, in addition to the typology that they present of the techniques for bending science, that is shaping it, hiding it, attacking, harassing, packaging, or spinning science, you ask yourself as you're going through the case studies, is this a case in which it's clear that somebody stepped outside the line and what we have is an enforcement problem, or is this a case where the line is fuzzy? So I think you'd need different remedial techniques to deal with those two problems. Let me just give you some quick examples. What would be on my matrix, just a couple of examples. They give an example on page 68 of Dr. Walsh, a distinguished researcher at the NIH who was a world expert in treatment of fungal diseases. And the FDA faced a situation of a proposal that they approve a drug that would be a marketed substitute or alternative to what was then the benchmark drug for treating a certain kind of fungal disease. The problem with the benchmark drug that was out there is it had some nasty side effects, including it could kill you. So the idea was you could make a lot of money if you could come up with a substitute that was pretty near as effective as the benchmark and didn't have these nasty side effects. But how do you decide to run a comparative effectiveness test? Well, you've got to have two study groups, one in the condition of being given the benchmark and the other in the condition of being given the candidate new drug. But what dose? What dose do you apply? Apply too light a dose on the benchmark drug, and it will show a relatively low level of effectiveness. Of course, drive the dose up, and you begin killing more people. But there's a range in there where there's some discretion about what level of dose should you use for the benchmark, and then the drug manufacturer has a suggested recommended dose for their new product. Well, Walsh, it turns out after the fact, is getting a lot of money from pharmaceutical companies. They're in the business of applying for FDA new drug approval, and he recommends a dose that either is on the very low end of therapeutic for the existing drug, or maybe even below it. In any event, there are a considerable number of people after the fact who think that the dose for the benchmark drug should have been much higher than was used in the test. But in large part because a low dose was used, the trial drug turns out to look pretty good in an effectiveness comparison against the low dose. Walsh is eventually found out. He's accused of unethical, unprofessional behavior, of violating NIH regulations. And by a quirk of the civil service rules, he can't be directly disciplined by the NIH, but they recommend that he be sanctioned by the Public Health Commission Corps. I don't know whether there's an after story as to whether or not they actually went through with that. But I would call that a case of pretty clear Dr. Walsh is operating outside the lines. Take another example, this one of the efforts by the chrome industry to do some studies to try to head off further regulation of chromium in the workplace. And so they do some studies of 2 plants in the United States and 2 plants in Germany. Don't like the results that come out when you combine the data, but they discover that if you separate the plants by those geographic locations, you can produce 2 results, one which shows no statistically significant impact from chromium at the level of exposure, and the other that shows impact only at the very highest levels of exposure. So they published the disaggregated results instead of the overall results. Well, epidemiologists have a word for this kind of activity, a phrase. They call it lumping and splitting. You take data, you lump it, you split it, you can massage it to mean a lot of different things. We've all heard statistics, lies, damn lies, and statistics. Well, a lot of epidemiologists will tell you that epidemiology is a way of describing an undifferentiated mass of data by using statistical methods to give you some descriptors for the significance of that information. So you can divide it in half, you can lump it together, you can slice it by time, you can do lots of different things with it, and there's often, under the circumstances, no clear-cut canonical version of the absolute correct way to do this. Because there are an infinite number of ways that information can be described. The story of the 4 blind men in the room trying to describe an elephant. They've all got valid descriptions of something that could yet be described in dozens of other ways. And epidemiology is one of those professions that's like that has a lot of different statistical tools for describing data. And it's not at all clear, had they chosen the disaggregated approach ex ante, that you would see a problem in that. The fact that they've done it ex post, the fact that they've found out, I don't like that description, let me give you another description, sounds pretty bad. It's also exactly the thing that lawyers do all the time with cases. So that's a little harder problem. Where is the line there in that kind of, they haven't manipulated the raw data. The raw data they accept. But they've manipulated the characterization of it. That's a little trickier problem. Another tricky problem is in the examples they give in their chapter on spinning science. Again, the idea that you're using public relations firms in the kind of aggressive and often distorting and unethical ways that they describe in the book, I think, to my mind, are relatively clear-cut cases. But the proposition that it is, there's a line to be crossed in the way a firm that's got a lot of self-interest wrapped up in a scientific decision frames a message or characterizes a message is a tricky line to figure out. Where I come from, the easy example of this is the Duke lacrosse case, which may be familiar to some of you in this room. It certainly is familiar to anybody who lives within 100 miles of Duke University. That incident in which a bunch of our lacrosse students were found in a party and an accusation was made by the exotic dancer who was at the party that she had been sexually assaulted by 3 members of the Duke lacrosse team. black, exotic dancer from the poor part of town, wealthy white university, fairly wealthy lacrosse families, aggressive sexual behavior, drunkenness involved, had all of the hallmarks of a public relations disaster for Duke University, and it was. Now, if you talk to the leadership of Duke, one of the things you'll hear often from them is we should have had a good crisis management firm come in who really understood how to get on top of this story so that we could get our story out. So the feeling was that our story had just been buried by the fact that the district attorney gave 71 interviews within the first week, went on TV, was excoriating, was indicting, trying, and convicting these 3 students in front of the camera. He's since been disciplined, filed for bankruptcy. The world has ended for Mike Nifong as far as that goes. But you can't, the truth never catches up with a lie in those kinds of situations. And Duke, I think it's fair to say, would have been a lot better off if it, instead of doing what it did, which was to say, let's back off, let the criminal justice system play out the way it will eventually. That's where due process is going to be played out. If they had kind of tried to aggressively frame the story in a way that's complicated, but you could figure out how to do, they would have been much better off. Well, one way of saying that is Duke didn't spin the story for Duke University. Is if they had spun the story, are they on the wrong side or the right side of a line? I think you confront some of the same problems with respect to some of the circumstances in which companies who have a big stake in a science outcome, the science is at least somewhat up for grabs, decide that they're going to be aggressive about representing their point of view on what the right science answer is. Now, at some point, this becomes bent science. I mean, Tom's done a lot of work on tobacco, and tobacco is the classic case of there now being fairly good evidence that in the boardrooms of the tobacco companies, they knew exactly what they were doing, which is they weren't telling the truth about their product. Other situations are going to be a little bit, they're going to be in more of a gray area, where there's some evidence some way, some evidence the other way. The weight of the evidence seems to be going against you, but it's not all the way against you. Doubt is our product is the tobacco mantra, which they continued well beyond they had any doubt. But, you know, one of the hallmarks of an entrepreneur is they're very optimistic about their potential for success and about the bona fides of their product. And it's often hard to persuade somebody who's about to lose a lot of money if the evidence is still contested that they just ought to give up and not challenge the public perceptions in the strongest way possible. Spinning is most effective when you're dealing with an issue that involves the legislature or public perceptions, less effective when you're doing work before administrative agencies and juries. So there's another typology you could develop in terms of these techniques. But it's also an area, I think, that in which the line is particularly fuzzy. And then, of course, you have little nasty problems like the First Amendment to worry about if you want to develop some strong rules for regulating the way people try to frame messages. I got a little bit to say about remedies, but I've already taken too long, so I'm going to stop with that kind of set of introductory remarks and let Don take over, and then we can do something more in questions. Thank you.
Well, I knew I made a serious mistake when they asked me if I cared in what order we went, because Chris made a number of really excellent points that I had hoped to make. I even had the Casablanca line in mind, so I'm not going to use that. But I do think Chris has put his finger on a couple of the key issues, and one of them is this line drawing problem in terms of whether or not there are legitimate uses of what I'll call advocacy science. But let me start out by saying this is an excellent book. It's one of the best books to be written in the law and science area in many decades. It's a perfect Christmas gift, and I recommend that you all buy it and read it.
I should plan to
It's original. An awful lot of what's been written in the law and science area for the last 40 years has all been derivative of C.P. Snow's The Two Cultures problem. This is a very original. It deals with a very real problem. It makes apparent what is a very significant problem in the legal system, particularly the regulatory side, and I think it's very readable. It's very well researched. And I'm in general agreement with most of the remedies that they talk about. Certainly, there's a great need for disclosure. Wendy, in an article in Science in 2003 with David Michaels, has proposed some really strong mechanisms for disclosure of interest and bias in regulatory science, and I certainly agree with that. I've been a long advocate of more use of neutral consensus panels and other of their recommendations. I think that's a good idea. They mentioned codes of conduct, and I think that really has to do with the line drawing problem, and I think that maybe is a part of it that's a little bit underdeveloped. And I'll talk a little bit more about what I think we ought to do in that area. I also agree with their idea that we should have some remedies for harassing scientists. Abusive discovery is a general problem, but I'm glad to see that they're supporting some remedies there. I'm not as on board with the notion of forging ahead without sound science, as they say on page 282. That does seem to me a little bit like throwing in the towel, but I've been a long-time supporter of technology-based standards. I was general counsel of EPA when we passed the 1990 Clean Air Act amendments that took Section 112, which had been based on the need for a lot of science, and made it into technology-based. So, if that's all you're talking about, nobody can really disagree with that. But I do think there are, so there's an awful lot to like in the book, and that actually makes it quite hard to be a commenter because you don't want to just praise it. But there's an awful lot in it that's very valuable, and I think that they've done a great job in terms of making a very real problem apparent. As often happens when somebody deals with a new problem, they get 80 or 90% of it right, but they don't necessarily get it all right the first time around. And I do think there are two problems in the book, which it occurs to me are perhaps somewhat related in a subtle way. First of all, I think they underestimate the power of non-monetary biases. And then secondly, and relatedly, I think their search for the truly disinterested scientist is a little bit of an impossible task. Reminds me a little bit of Demosthenes, going around with the lantern, looking for the truly honest person, and never finding one. There are a number of other institutions that have pursued this issue in the past, and I think they don't talk as much as they might about some of the experiences that the National Academy of Sciences has had in dealing with these issues over the years. And after many years and a lot of experience, I think for some good and sufficient reasons, the National Academy has given up on the notion that you can find truly disinterested scientists for the panel, and has gone instead to the notion of disclosure of biases and trying to balance biases. And I think there's some good learning in that. They attribute a lot of the problem to the notion that scientists, particularly in the regulatory area, are not, quote, disinterested, and they flirt a little bit in the book with the notion that, well, maybe we should only allow truly disinterested scientists to speak on these issues, or that we should base our decisions only on science that's done by disinterested parties. But ultimately, they don't go there. They back off, and they don't really take that position. And I think for some good reasons. I think most of us think that the First Amendment protects the right to do science, and it also protects the right to comment on proposed government decisions. And they also recognize that there would probably be insufficient funding for science, particularly of the sorts that we need in the public policy process, if self-interested parties were not contributing to it. So I think that really leads us to the kind of line drawing problems that Chris was talking about. You can't really get rid of self-interest in human affairs, at least not in a democracy which has something like our First Amendment. Well, let me talk about those two problems, and then maybe where I would come out a little bit differently on some issues. First, turning to the one about underestimating the effect of non-economic biases. I think much to their credit, they do at least give lip service to the notion that the so-called special interests that they're criticizing are not all corporations. They say on page 38 that all parties who participate in the public policy process are guilty, including specifically the self-appointed public interest advocates. But in fact, the overwhelming majority of the examples that they give thereafter are of where corporate interests are corrupting the scientific process through the use of money. And they even have one passage where they assert that corporations probably do this more than other groups for some reasons that they give. But I'm not persuaded that they've really made a strong case of that. I think what they underestimate is what I've come to call the hedonic fallacy. And that really came from an article I read a number of years ago by Milton Friedman in his introduction to Friedrich Hayek's book, The Road to Serfdom. Friedman put a very interesting proposition. He said, since socialism doesn't work, why doesn't it die out? Why do people continue advocating it? And his answer was, it makes the people who are advocating it feel so good about themselves. And I certainly have had the experience in my lifetime of taking a position where I felt I was really saving humanity. And that was a much headier experience for me than working for a dollar. So I think that we have to be sensitive to the possibility that sometimes people are not disinterested for reasons other than monetary reasons. Recently, EPA threw an environmentalist off one of its scientific advisory committees because she had testified the day before in a state legislature that the chemical that she was going to be considering the next day should be banned. That kind of pre-commitment to an outcome is also a bias. And I think most of us, as a result of our previous life experiences, have various biases. And I think it would be very, very difficult to create a system in which all the people who are allowed to participate are, quote, disinterested. It's actually interesting. The whole book gives examples of people who are interested in various ways. It doesn't actually give us any examples of the norm on the other side of the truly disinterested scientists. So I'd like to see some examples of who might qualify. But they really, moving to the second point about this focus on being disinterested, they say that the first norm of science, either creating or reviewing science, is disinterested. And they remark with horror that some experts are willing to work backward from the outcome in order to advance the interests of the party for whom they are working. That's where I was going to make the Casablanca remark that has already been preempted. I think what's going on there is what's called the fallacy of composition. They are using a very general term, science, to refer to several different things and thereby sort of muddling them together. An example would be, an analogy would be if we were to use the word law to apply to what judges do, what professors do, and what practicing lawyers or advocates do. We could say, well, they're all doing law, and some of them are interested in the outcome because they represent clients. A number of years ago, Stephen Goldberg at Georgetown Law School wrote a wonderful article in the Georgetown Law Journal called Law and Science, The Reluctant Embrace, in which he compared law and science, and he predicted in that paper the emergence of what he called science advocates or science counselors. Those are scientifically trained people who do what lawyers do, who advocate, who are policy advocates, but do it on a scientifically trained basis. And I think what really sets up the problem that they are talking about in their book is that we've seen the emergence of this new profession of science advocates, but we really haven't developed the appropriate codes of conduct, or what Chris Schroeder calls the appropriate line drawing, as to what are appropriate and inappropriate instances of being science advocates. So I do agree with them in terms of the nature of the problem, but I don't agree that the solution is to develop people who are purely disinterested, but rather to try to establish the legitimate ground rules, or what Chris was talking about in terms of line drawing problems. Now, it's sometimes tempting from the luxury of the university or the government to feel superior to poor working stiffs like me, who actually have clients who have positions or interests. And I think that is in and of itself a kind of bias, that only people who are disinterested financially in the outcome can really contribute to the process. To me, the issue is whether or not it's possible to be ethical and also to be an advocate. And as someone who teaches in a law school, still teaches in a law school, I feel very strongly about that issue, which I think is very analogous to the issue that they're putting in their book. I was asked to give a lecture in Texas, as a matter of fact, a number of years ago about whether or not law was an honorable profession. And I said, no, law is not an honorable profession, but it's possible to be an honorable lawyer. And I think that's a very important distinction. I think the fallacy in their book is that they assume that it is impossible to be an ethical science advocate. They insist that the only way that one can be an ethical science advocate is if one is, quote, disinterested. And I think that that causes them to perhaps draw the lines in the wrong places and underemphasize the importance on developing ethical codes and rules for this new emerging profession of science advocacy. So I believe that interested science or science advocacy can make a valuable contribution to the regulatory process, but it has to be disciplined, it has to be policed, there have to be codes of disclosure, but also codes of conduct as to what is legitimate advocacy and what is not. Let me give you a couple of examples. One point in the book, on page 14, they refer to what they call highly sophisticated trickery, such as concealing the provenance of commissioned research or recruiting the best university scientists to critique unwelcome research. Well, in that sentence, I think, again, you see the fallacy of composition. I think concealing the provenance of research, that is, concealing that you've been paid to do research, so you're masquerading as if you were a law professor or a judge when you're actually an advocate, I think that's unforgivable. And I certainly support the position that they take in this book and that Wendy and David Michaels have taken earlier, that when people have been paid as advocates, we have to understand that that's the role they're playing. But the second half of that sentence, that it is somehow highly sophisticated trickery to recruit the best university scientists to critique unwelcome research, there I have some difficulty understanding what is supposedly wrong with doing that. Are people who are advocates in the regulatory process not supposed to recruit the best scientists? They're supposed to recruit the second best scientists? Are they supposed to critique welcome research, not unwelcome research? Are people in universities not supposed to dirty their hands by getting involved in something like the public policy process? So it seems to me that there's a confusion revealed there between whether or not policy should be simply left to those who are disinterested, or whether or not there's a role for people who do have an interest in the process, but in terms of establishing what appropriate roles of conduct might be. So I strongly would support disclosure rules as they do. I also think that doesn't go far enough. I think we need specific codes of conduct as to what is legitimate or not legitimate. I don't think that data dredging or selective presentation of your data, or not disclosing the changes that you've made as a result of a sponsor intervention. I think there should be clearly established codes of conduct that put those kinds of bad practices off limits. Those are like the rule of ethics that we lawyers have in Rule 3.3 of the rules of professional conduct, for example, that it's not ethical to fail to disclose to a court the controlling authority in a jurisdiction if it hasn't been cited by your advocate. It's not ethical to, even as an advocate, to make a misrepresentation of fact to the tribunal. So I think that what is going on in this field is we've had the emergence of science advocates, but we haven't developed codes of ethics or policeable rules of conduct as to what is legitimate science advocacy and what is illegitimate. And I think you see this in some ways in the book, in the sense that most of the examples given in the book are examples where one side or the other advocated a flawed position. But in the overwhelming majority of cases, ultimately from the clash of these flawed positions, the truth emerged, and it eventually at least came out. That really is the nature of the adversary system, and it does seem to me that it is inevitable, for some of the reasons that they identify, that regulatory science is going to involve a clash of interests and will not just be made by disinterested platonic guardians who have no interest in the outcome. So I think the challenge is to come up with techniques, rules, limits that police the exercise of regulatory, of scientific advocacy, but not to throw the baby out with the bathwater by assuming that we can find perfectly disinterested scientists. Thank you.
I'd like to invite our speakers up to the bench behind me here so we can have some Q&A from all of you. At the very beginning, since Tom joined us a little late but was here for the commentary, I was going to give Tom the chance to offer some brief comments of his own or some responses of his own, if you'd like, and then we'll go to questions from the audience. So, Tom.
Sure, thanks. Well, I'm sorry I'm late. The pilot didn't show up for our plane for about an hour. That was honest to goodness truth.
Probably some interested regulatory participant.
Maybe so. Maybe so. I'm not sure what I think it was because they just don't like Cleveland. But in any event, please, I certainly thank you for having me here. And this is my first time in Cleveland, so I'm enjoying my stay here as well. Once I got here, I spent too much time in Dallas-Fort Worth, where I've spent many hours. In any event, I guess let me respond a little to what Don had to say, because I was very happy to hear that he likes this book as much as he does. The last time I was at one of these that Don commented on a book that I wrote, he hated it and thought it was really
It's a much better book.
Disappointment. So this is pleasing, and in fact I'll probably surprise Don to say a bit that I kind of agree with him that it's very difficult to find disinterested scientists, and maybe that is a desideratum that we might strive for, but never achieve. I'm one of those. One of the reasons I'm a proponent of technology-based standards is that I'm an El Dorado kind of a guy. That I think that the good of the quest is in the quest itself and not so much in the getting there. So I think that to try to find disinterested scientists is at least something that's worth doing. And in fact, when it comes to advisory panels, for example, we use the National Academy of Sciences example. There really are kind of two models. One, the Federal Advisory Committee Act, which does talk about balance, and I like that. And I do think that balance is one way to deal with the possibility in some areas that there is no real way to isolate or determine who's disinterested. And in fact, if we did allow some government agency, for example, to select only, and we made the rule be only disinterested scientists, and the agency got to decide who those were, I would be worried about that system, for fear that you would stack the panels just as easily by the choices that you made. So there is that Federal Advisory Committee Act model. On the other hand, I think if you just expand the range of scientists so that you don't require for a particular issue, say the dioxin, the long-term effects of exposure to dioxin, if you don't limit the scientists there to scientists who have studied dioxin, in fact, if you don't limit it to scientists, toxicologists, but you let just scientists who understand science and how science is done to participate in those panels, appoint those folks, and don't push this notion of expertise too hard, because all good scientists know how to do science, and if what we're looking for really, as we suggest in the book, is to find places where science is being bent by looking very carefully at the data, sometimes for the first time, because peer review doesn't always work as well as we'd like for it to, then you don't have to be a part of that specialty, I think. Now, the scientists have a lot of trouble with that. They're very much into specialization. So that's a hard sell to the scientific community. He said we don't have an example of disinterested scientists, but I think we do have an example, at least one. They were hard to find, but one example of disinterested science, of putting together a panel of scientists who led or achieved what we regard to be a disinterested result, and that's the Health Effects Institute at Harvard, which was formed by the automobile industry and EPA to deal with scientific issues, to commission research and that sort of thing. But certain issues have been referred to, and we mentioned at least one in the book. We have more on HEI in the book. But part of that is the confidence that the public can have in what they do. Is it wasn't just scientists. The chairman of the board is Derek Bach, or at least when it got started. He's a lawyer, former dean of the Harvard Law School. People who we have some confidence in for their integrity. And I also tend to agree with Don that perhaps we should have, if we were competent or capable of doing it, and we didn't regard ourselves so much as competent in determining what the rules of conduct ought to be, or what the codes of conduct ought to be. Indeed, as the sort of first draft of this book was going on, we talked about rules of conduct and suggested, well, there just aren't any. And we presented the manuscript at Albany 2 or 3 years ago now, and one of the panelists, there was 2 or 3 panelists, or 2 or 3 participants in this workshop devoted to the manuscript, which was a wonderful experience for us, that included Bernie Goldstein, who Don knows really well, and said, well, you're just wrong about that. And he's now, I guess, the dean at Pittsburgh Medical School. Was it Pittsburgh? Is it?
Yeah, he's not the dean anymore,
But he was maybe at the time.
Right.
Yeah. Well, you're including too much. You're within this word, or this concept of science. You're trying to do too much, and that's true. And I think what we intended to do early on in the book was limit the book's range to what we call policy-relevant science. There's an awful lot of science out there that's not policy-relevant at all. Perhaps because of this book, I was appointed to a panel of the National Academy of Sciences on the integrity of data in an electronic age. And a lot of that science just flat isn't policy relevant. It has to do with terabytes of data coming down from the Hubble Space Telescope pointed at the heavens, and things that are going on at the CERN proton accelerator. And maybe at some point that will be relevant, but at this point it really isn't. So there's a whole huge amount of science out there that isn't affected by the problems that we see. I want for there to be time for questions, so I don't want to take any more time than this. Thanks again for having me here.
Thank you, Tom. Are there questions from folks? Yeah.
Sorry, not sure the title. Professor Elliott? Try that.
He taught my daughter, I know that.
But for the code of conduct, it seemed like you offered two different alternative solutions for this, whereas you could either professionalize it or more like public regulation. So I was wondering, out of those two options, I kind of have a feeling which way you're leaning, but out of the two options, which one do you think is stronger, like public regulation like the SEC, or more professionalized like the legal profession, just adding legal enforcement, which it seemed from Professor Wagner's presentation that's their approach?
Yeah, that's a really good question. I think it ought to be both. I think you need the expertise of the scientists to help develop what the appropriate criteria are, because I think, as Tom said, it's hard for any of us outside of the areas to really be smart enough about how data can be manipulated to identify that. But then I think it ought to be more than just a self-regulation by the profession. It ought to have some teeth and enforcement mechanisms. So I think the model that we use in terms of the law, where you have the profession that develops some recommended standards, but then they're ultimately adopted and enforced by public regulatory bodies, would be the kind of thing I might have in mind. I do think some of the things are not that hard, and there's a lot of low-hanging fruit in this area. We do have a lot of people that are currently testifying before National Academy of Sciences panels, are being paid to do that, and do not disclose that they are paid advocates rather than and they masquerade as independent scientists. I think that's outrageous. That would not be permissible for a lawyer. If you're testifying and you're testifying not as a disinterested professor, but as a paid advocate, you have an obligation to disclose that. So some of the stuff is easy. Other stuff, and I think they give a lot of examples in the book of the subtler ways that studies can be manipulated. I think you need some professional societies to develop. But I actually have it in my briefcase. But the report that Wendy and some of her colleagues did for what you showed that
progressive reform.
Yeah, you showed that briefly in your PowerPoint.
Right. They
have 9 rules that they propose. And I think that's an excellent start. We don't have a good enforcement mechanism, but I think you could have some pretty clear codes of conduct. But you start with the notion that if you are that you have to disclose whether or not you're an advocate for a position, and if you're an advocate for a position, then what you say will be evaluated differently than if you're purporting to be a law professor.
Other questions? Back here. We just wait for the microphone. The event's being webcast, so folks at home or wherever they are can hear as well.
I should explain I'm a professor of epidemiology, so since that was brought up on this, I think there are domains for which we are disinterested. If you came to my department, we argue forever about how to cut or split or divide or what form of a regression model to use to do that. There's endless discussion, and some of our faculty will simply flip a coin and argue one side or the other. I just assume, as good lawyers would in this room, if asked to say, pick this side or that side of the case. There certainly are. Another major area of interest is just pet enthusiasm. I have a theory about how the world works. I really will look for the data to support my theory. It's not a drug company or anything like that. I'm making my career on X theory, and I'll try and design the evidence in that way. I think the thing that is really missed at the core, science is driven really by replication. You may have an impassioned feeling one way or another, but do other people with exactly the opposite views do this? And I think one of the important things we could do is very clearly make sure that studies that are put forward could be repeated and are carefully enough designed so that, and reported so this can be found.
Right, that's a great point.
Yeah, I think that's an excellent point. I think we'd all agree with that. And one of the norms ought to be that there be enough disclosure in the publication that it's susceptible to people attempting to replicate it, and they do in fact talk about that in the book. I would just make one point, if I could, about the point you made about disinterestedness. I've spent the last 8 years as the lawyer on the Board of Environmental Studies and Toxicology at the National Academy. I'm about to reach my term limit, and one of the three of you would be a very good person to replace me. But one of the things that the National Academy has done for many years is make a strong distinction between what they call conflict of interest and what they call bias. And I think that there are financial and other kinds of conflicts of interest in the outcome that are not waivable and are disqualifying. Then there are other things like biases, a commitment to a particular scientific theory or prior publications. Those need to be disclosed so people can evaluate them, but they're not necessarily disqualifying. And I do think it's a helpful distinction. I would not necessarily disqualify somebody if they had a financial conflict of interest, but I think their financial conflict of interest should clearly be disclosed so that somebody who is functioning as an advocate can't be masquerading as a non-advocate.
Just one further point. When it comes to epidemiology, one thing that this committee I was on has run into is sometimes if what you're talking about is gathering the data again in terms of replication rather than just reworking the statistics, it can't be done, right? You can't, I mean, the history is the history of Hiroshima, and we're not going to have another bomb just so we can to replicate the data, right? And that's true in epidemiology. It's also true in astrophysics to some extent.
I was going to take the moderator's prerogative to throw something out for the whole panel. In terms of, one thing that came up in the discussion is what drives the pressure to bend science. And obviously one of the issues is that in tort litigation and regulatory decisions, there's a lot of money on the table. And if industry or whomever else has money at stake, they have a strong incentive to influence that decision. I'm wondering if another factor that leads to the tremendous pressure to influence science is that we both have statutes as well as a broader policy culture, which sometimes masks what are essentially normative policy judgments as if they were scientific judgments. So we say sound science compels X, when really what we're saying is from a particular value commitment about how precautionary we should be or how we should weigh certain types of things, we would choose one or the other. And that given our political culture that is susceptible to that, and in some cases even a regulatory structure that's susceptible to that, it makes science a trump card over what should really be wide open debates about values and normative preferences.
Well, Wendy's the obvious person to answer that one, having written the seminal article on the science charade years ago.
Yeah, I mean, I completely agree that sometimes science is used as a trump card. Absolutely. We don't talk about those issues in this book, though. We're talking about sort of more raw scientific research. But absolutely science is misused. Frankly, that's another reason to try to dodge it. We don't do a good job in public policy with science. So that's yet another problem that we keep encountering. So we'll keep fighting with Don at dinner about how we need to really have all the science used in public policy unless absolutely necessary. Not to put the epidemiologists out of a job, of course, but everybody else maybe, yeah.
Yeah, so this is a lifelong conversation among the four of us. Wendy and Tom and I were in a dialogue at the administrative law section, I think in 1999 or 2001, which we published about some of these issues. The way I model it, and this is based in part on my experience at EPA, is that science does not decide most issues, but what it does do is it often defines the range of discourse within which policy judgments can be made. In other words, there are often in regulatory decisions limits to results that would be indefensible in terms of indefensible under the science one way or the other. But you almost never have a situation where science specifies a unique result. So you often have a situation where the science will, imperfect as it is, establish a range. And I think that's why, to some extent, the invocation of technology-based standards, while useful and something that I would support, it doesn't really make the problem of science go away, because you have to decide what things are sufficiently hazardous that you want to use technology-based standards to regulate them in the first place, and you can't develop technology-based standards for everything all at once, so you have to set some priorities. But I think we'd all agree that science does not eliminate the need for public policy, and sometimes it's misused as a rhetorical resource. So it's really a question of how much science, and really I think more a question of when to make a decision. When do you have enough science? When is the science mature enough that you should make a decision now as opposed to wait until a later date when you may have more science?
We have time for one final question if there, sure there's someone somewhere.
This is sort of mundane and concrete, if you'll forgive this, but as a lawyer representing a client, often we have an obligation not to present false information. So if you're a lawyer representing a company in, for instance, an administrative proceeding, or, well, more commonly would be a tort case, but my experience would be administrative proceedings, in the concept of the ethical advocate, could you comment on the function of the attorney when presented with scientific data by one's client in terms of finding another way possibly to police this unsound or bent science?
Yeah, well, I think that's an excellent point. I think an attorney would not be permitted under the current rules of professional conduct to present information given to him or her by a client which he or she knows is false or misleading. The difficulty is that the current ethical rules use the word knows rather than suspects, and do not necessarily impose a duty of investigation, and that's been a very controversial issue with the SEC and others taking the position that attorneys ought to have an affirmative duty of investigation. But I do think you make an excellent point that one of the ways that we could develop some of these codes of conduct is by using the attorneys as essentially gatekeepers. And I think that's an excellent way to look at it. See, one of the problems with the code of conduct approach is that there aren't necessarily professional societies or certifications for science advocates, because that profession is still in its infancy. So you can't disbar someone from being a science advocate. You'd have to either use the professional societies to certify people, or I think a better approach really is that people ought to be admitted, that scientists ought to be admitted to practice before particular agencies in the same way that lawyers are. And that in order to do that, there could be roles, and somebody could be disbarred from continuing to practice before the FDA or the EPA if they were found guilty of scientific misconduct. But I think what Wendy and Tom have done is surface a really big problem, and I think that now we enter the age of really trying to figure out how we're going to grapple with it and how we're going to solve it. But I think we have to accept the notion that people are going to be interested, in the outcome and are going to employ scientifically trained people as advocates. So I think we have to develop the rules of the road. I mean, one way to think about it is, you know, the adversary system is inherently combat, but it ought to be combat conducted under Marquess of Queensberry rules rather than total war in which anything goes. And the problem in this area is because it's just emerging, we don't have the Marquess of Queensberry rules as to what is and is not legitimate. I think that's exactly the line drawing problem that Chris was pointing to and really runs throughout the book. We've got to decide what is legitimate, what is not legitimate. We have to then have clear signals that this goes too far and some sanction for people who goes too far. We don't have any of that yet, and it's like the old Wild West.
Just one point, and that is, Wendy and I struggled for hours and hours and hours about this, which was, should we try in the recommendation section to define what's legitimate and what's not legitimate? And we finally came to the conclusion that really isn't our place, because you need to know much more than we knew or were willing to try to find out. In the amount of time that we had to do that. So we certainly considered it. We
Well, there's some
really
other
thought there was
books.
a certain.
Other people can write books in this area
That's right.
too, Tom.
We need. That was my invitation to you guys to write.
You guys created the field. You know, you started the field. You hadn't necessarily finished it yet.
That's right. It's up to people like you, Don, to go ahead and tell us what the.
What a note to end on.
Well, please join me in thanking Wendy, Tom, Chris, and Don.
Thank you so much.
Very quick, there's a reception on the other side of this wall here in the lower rotunda. Please join us there. Also, this event was webcast, so if you enjoyed it, want to watch it again, recommend it to others. It will be archived on the case website. But thank you all, and have a good evening.
Guaranteed to publish them, but they have basically said they'd like to look at
Right.
what grows out of this.
Oh, really?
That would be
So we're gonna-
great.
I need to show this because it might be contraband because it has illegal